submission.
Yes, first and foremost, Mr. Impleading, your matter is a hearing matter, no? You do one thing. I had appointed amicus.
Yes.
You remember?
My lord.
He had given a note.
My lord.
I will have this matter on Wednesday.
My lord.
You have a look at this and kindly forward this to Miss Livika.
Levika.
She's there on the other side. Huh? So here he has pointed out the defects in the report which have been given by the district judge, whom I have asked for submission of an inquiry report. These are the defects which are being pointed out.
My lord.
This is for your advantage, and it goes against the state. But then also I have to give her a copy of this. Please put this thing in that file. We'll have this matter on Wednesday. Have a look at this and argue on this point. These will be the item numbers. 19 and 20. We'll have it on Wednesday.
My lord.
Okay.
Much obliged.
Usually on Wednesday there is a division bench.
No, on Wednesday there is a division bench with the chief and I think Justice Das, not with me. Tomorrow I am sitting with the chief.
Please, Your Lordship. Lordship, I beg to mention item number 15.
15?
Yeah, 15. Lordship, here I'm yet to complete my affidavit of opposition. So this letter, this matter will be listed on Monday, 1st September.
Next Monday?
Yes, before that I'll file the affidavit.
Your Lordship, we have no objections to your prayer.
Huh?
We have no objections to your prayer, Your Lordship.
Okay, at the request of Mr. So-and-so, the learned counsel, the matter stands adjourned to be listed again on Monday. Put the date, huh?
Your Lordship, this is an interim indirect petition as well as
There's
the
an
IA.
interim prayer?
Yes, Your Lordship.
The interim order passed earlier shall continue till then.
Yes. Much obliged.
What is this IA for?
Here for interim, actually this is regarding the issues of the Indigenous inhabitance certificate. So we have started for enumeration of all those particular tribes. So they have stated an enumeration of those.
So there's a stay operating.
Yes,
Yes.
Your Lordship.
Okay. Be ready on Monday.
Yes,
We'll
Your
finish it off.
Your Lordship, there's a stay in the IA as well.
So that stay I've extended it. No?
In the writ petition as well.
Interim order passed in the writ petition as well as in the interlocutory application stands extended till the next date.
Much obliged.
Bishop, item number 7. If this be taken up tomorrow.
Yes, what is this?
It's you can discharge, Lordship. Discharge.
You want time?
Tomorrow, Lordship.
Tomorrow, I don't think it would be possible. We can have it day after.
On Thursday, Lordship.
Thursday, no problem.
Watch.
At the request of Mr. Gauhati, the matter stands adjourned to be listed on Thursday. Put the date. Huh?
Watch.
May I please, Your Lordship. Lordship, I beg to mention item 6. I pray for 1 week to file my affidavit. I've sent it for vetting, Your Lordship.
You are for the petitioner?
And for the state respondents, Your Lordship.
You want to file?
Affidavit in opposition.
Lordship, I am for the petitioner, Lordship.
No objection.
Lordship, 1 week last chance may be given, Lordship.
Huh?
Last chance may be given, Lordship.
Last chance.
Lordship, I'm for the private respondent number 6. The 2 weeks time may be granted to file an affidavit.
But this is a matter pertaining to 2024. Does it look nice? You have got enough chance. We have it next Thursday, Wednesday. By the time you complete your pleadings, both of you, okay? A last opportunity is being given, is provided to both the state respondent as well as the private respondent to file their affidavit on or before 2nd of September, on or before 2nd of September. List this, the matter again on 4th of September.
Much obliged, Lordship.
Lordship, I will pray for item 16 as well.
16?
16. I'm yet to receive any instructions, Your Lordship. I pray for 3 weeks, Your Lordship.
The Mr. So-and-so appearing on behalf of the state council, state submits that he requires 3 weeks' time for filing the affidavit. List this matter on 15th of September 2025. In the meantime, the state respondents shall file their affidavit on or before, and put it on 22nd September, on or before 17th of September.
Your Lordship. Yeah, please, Your Lordship. Lordship, I beg to mention item number 3, Lordship.
Item number
Item number 3, Lordship.
3.
Lordship. Lordship, I have sent for vetting, Lordship. So if Lordship may please to list the matter
3
after.
2024 matter.
Lordship, I have sent for vetting, Lordship. And I'm waiting for the
Therefore,
signature.
For the respondent number 5, Lordship.
you have filed the affidavit.
Lordship, Lordship.
Huh? Okay. Mr. So-and-so, the learned counsel appearing on behalf of the state respondents,
Lordship.
submits that he requires a week's time for
Lord.
filing the affidavit. List the matter again on 4th of September 2025. Hey, why this is the principal seat these people have given it? Yes. 4th of September. 4th of September 2025. In the meantime, the affidavit be filed on or before 3rd of September.
Lordship.
Lordship.
Okay.
Please, my lord, I beg to mention item 8 to 12.
Nothing will remain, Mr. Counsel. Nothing will remain. Let me sit for half an hour. If you are mentioning all
Item 8 to
matters,
12, my lord.
we'll see when the matter calls. Today is the first day, so initially I have granted some adjournments.
For motion, item number 1.
Yes, Mr. Moajamir. What is this?
Lordship, I was appointed as private on 6/6/2023. And 2 years, more than 2 years has lapsed.
Amen?
2 years. I'm here to be paid salary, as well as I'm here to be attached with an officer.
Where's your
I'm a
appointment
driver.
letter?
Appointment is page 22, Lordship. Page 22.
You were appointed in 2023,
23, Lordship.
June. PMS code of the retired employee against which the vacancy, the appointment is made. And then confirmation is also there.
Yes, Lordship. Page 24, Lordship.
Then you have not been paid your salary.
Yes, Lordship.
My goodness. Yes, government, what is this?
Your Lordship,
How will you survive?
Lordship, I may be allowed to take instructions.
Yeah, non-payment of salary. Okay, issue notice making it returnable on 8th of September 2025. Ms. So-and-so accepts notice on behalf of all the respondents. Extra copies of the writ petition be served upon her during the course of the day by tomorrow. The case of the petitioner herein is that the petitioner was appointed by an office order dated 6/6/2023 to the post of driver grade 2 in the Nagaland Public Works Department against a sanctioned vacancy.
Lordship.
The petitioner thereupon was confirmed by another order dated 19/6/2023. First of, the grievance of the petitioner herein is that the petitioner have not been paid his dues, his salary,
Lordship.
since the date of his appointment, and it is under such circumstances the petitioner has approached this court. The respondents herein are directed to bring on record their stand by filing the affidavit on or before 4th of September as to why the petitioner have not yet been paid his dues in spite of the petitioner having been appointed to a sanctioned vacant post
Lordship.
way back on 6th of June 2023.
Lordship.
Full stop. Pending notice, it shall not be a bar on the part of the respondents to make the payment to the petitioner of his dues.
Obliged, Lordship.
For motion, item number 2.
Yes, what is this?
My please, Your Lordship. Your Lordship, this matter pertains to the land dispute between the two villages. That is the petitioners and the respondent number 2 authority, my lord. And I filed this writ before this honorable court challenging the impugned judgment and order passed by the office of the Deputy Commissioner Longling, which I have annexed.
Wash and set aside the letter dated demand written by Tamni village.
Yes, my lord.
Set aside the judgment in order. Where is that order?
My lord will find it in page number 24, my lord, the judgment order. And on the following page, there is a type copy from my lordship.
Hearing the submission of so-and-so, so-and-so, on examining the agreement dated demand entered into by so-and-so, it is noted that the fine of rupees was levied in connection with the unauthorized cutting of trees to so-and-so. As per the agreement, it is considered view of this court that incident case is primarily not a traditional land dispute between the two villages warranting court. The land in question was forfeited in favor of the so-and-so failing to pay the debt of so-and-so. Therefore, the incident does not qualify to be settled through customer. And this court of payment upholds the judgment of that. Mr. Counsel, how are you exercising 226 in the incident proceedings?
If I may be allowed here, my lord.
Please, you are at liberty to say.
My lord, at the first instance, this matter has been tried before the office of the Dubashis Court Law, which is a subordinate administrative division of a Longling district, my lord.
No, listen to me, what I am saying. Wouldn't this case come within the ambit of Article 227?
Yes, my
Because
lord.
what has happened here, you are asking this court to issue a writ
Yes, my lord.
against an order passed in a judicial proceedings.
Exactly, my lord.
Can this court do so?
Yes, my lord, because my lord, as long as this letter is concerned, there is a violations of a fundamental rights from the petitioners.
If I may, Lordship, there's a number of appeal pending with the division bench, whereby challenging the jurisdiction of the district administration.
No. District administration, no problem. You can very well challenge under 226. But when it is a judicial order, because this is an order passed under 32, if I'm not wrong, 32 of the Rules of Administration of Justice.
Yes.
So under such circumstances, it's an appellate order.
In a way, yes.
It's an appellate order.
In a way, yes.
An appellate order by which the court can either, the
Now,
district
question is-
can either.
Lordship, the question is whether this district administration is a judicial court. That has to be decided by the division bench.
What does it say?
It is still pending whether the DC administration is a judicial body.
This is judicial administration. This is not in exercise of the power. It's a judgment and order passed
No, no.
in exercise of 32.
No.
So it would therefore has all the trappings of a judicial order.
No. So
It's a different thing that what happens.
Why I have approached this court in 226 is because the appeal is still pending before the Honorable Court.
That's a different thing.
Yes.
It's an appeal pending, it's okay. But the question is, the question of this court exercising the power, no doubt this court can very well exercise the power.
No.
There are two avenues by which this court can exercise the power. And the power can be exercised, there is a revisional jurisdiction conferred upon this court by a provision of the rules of administration of justice, isn't it, Mr. Counsel?
Yes, ma'am.
If I'm
Yes,
not
yes,
wrong,
yes,
show me
right.
the blue book. So then if that appeal is there, why you are not approaching that and moving under 226? The revisional jurisdiction is conferred upon this court. It's not a question of a violation of every right. If it is violated, would be of some. These are property rights. These are property rights. Are property rights. It may not be a fundamental right. It may be a constitutional right under 300A. But the fact remains that we have an appellate jurisdiction. Yes, it will come before this court. We can convert it.
Yes.
It is not that, I think this is a case where I should convert it, not 227. There is a revisional power, and the revisional power is akin to an appellate jurisdiction. So therefore, what you are asking, this court, the jurisdiction, 2262 in my opinion cannot. Now, as regard 227 also, the jurisdiction will be very less. But if we go by these rules, that day I delivered one judgment, I forgot. Where is that provision? Appeal to the High Court. Yeah, 32.
Yes, revisional power, sir.
So therefore, if I convert it,
All right.
the jurisdiction of this court will be much bigger.
All right.
And this court can very well do many things.
All right. All right.
Because what has happened here, the court has conferred, the DC has confirmed the order as of the order passed by the district council or the Dobasi court as his order.
Yes. Right.
So I think the only option should be you exercise 32. The High Court or the Deputy Commissioner may on an application by the aggrieved party or otherwise call for the proceedings of the by and so, that the party aggrieved by may move such an application only after availing of the remedy by way of appeal, if any, provided under the rules under the so. So this is an appellate order.
All right.
So therefore you can very well come here.
All right.
So I think you
Yes,
look into
yes,
it.
yes, Lordship.
And on to you, we have it on Wednesday. You just find it out as to whether because the problem which arises with this book is you don't know which has come in. And recently,
Yes, yes, Lordship.
and recently I delivered a judgment of where the senior Iralu was arguing on this point and what is a de novo and all. There I dealt with the powers of the revisional court, which this court has. And it is, and as held by the another division bench of this court, it says that the power is very wide. It is not a power which is similar to a revisional power. Under revisional power under 115 is very circumscribed. But this power is much more. It has the trappings of all an appellate jurisdiction. So then the power which this court can exercise will be much more. It will be better for you.
Yes,
We
Lord.
have it on Wednesday. Just find it out. And that asks the younger Iralu also, he may help you out.
Yes.
That judgment there I have dealt with.
My lord, since the matter pertains land issue, whether or not the state respondent will be a party.
No. State have no business out there. State, no, we'll take it out on that day. And instead of making a 226,
Yes,
we
ma'am.
convert it into a 32,
Yes, ma'am.
this 32.
Yes,
And thereupon strike out the names of the state respondents
My lord.
and proceed.
Yes,
Yes, ma'am.
And
I
this
think that
is
is
not
the-
state land, it's a village land only.
So therefore, we don't require, because if it is a 226, state will come in. But otherwise it is not required. Even in 227, the state has no business out there.
Since
But
we were made a
implicating the
party.
state out here means I have to ask them to file an affidavit. Now, the problem which will happen is you are allowing him to give evidence before this court,
Lordship.
which will have a more difficult proposition.
Yes, ma'am.
So therefore, I think the best option is converting into 32. Just look into this. I think 32 earlier, by the 1984 amendments, certain aspects have been touched. But otherwise, 32 as it is was already there. Have a look at it.
Yes, Lordship.
Okay, list the matter on Wednesday for motion. If anyone does ask them.
Item numbers 4 and 5.
May I please, Your Lordship? Yes, Your Lordship, I'm appearing on behalf of my senior, Mr. Estingen. My senior is in court number 2, and I've been instructed to pray for adjournment for placing some relevant records by filing way of additional affidavit. Therefore, if the matter may be listed after 2 weeks.
What is it? Nobody wants to do the matter. Huh? Was the appointment of the respondent number 6 issued by the principal director so-and-so? Huh? It's a simple matter. You are there? What?
I'm in subdivision number 1 and 2.
You are also the petitioner.
Your please, Lordship.
Ah, yeah.
I'm
he
for
comes.
yes, private respondent. Lordship, in the question of this date of birth,
Ah.
I have some materials which has been instructed by my client. So I want to place this record before this honorable court by way of making an additional affidavit. So a short time may be given so that.
So when did it, you must be in the midst of preparation of that additional affidavit, I suppose?
Lordship, because it is very relevant.
Huh?
It is very relevant.
Okay. You bring it on record by filing an additional affidavit by 2nd of September.
Lordship,
We'll take it up on
Lordship,
4th.
Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 6,
6 and in 1, respondent 4.
the private respondent.
Yes, private respondent.
In both the writ petitions, submits that he has got certain, the petitioner, the state private respondent wants to bring on record certain documents which have a vital bearing on the adjudication of the issues involved in the present proceedings. He therefore submits that he would be filing his affidavit by additional affidavit by 1st of September 2025. This is the matter on 4th of September 2025.
Lordship.
For admission, item numbers 8 to 12.
Please, my lord.
Yes, what is this?
Lordship, here I am challenging the order passed by the Deputy Commissioner Dimapur, directing the Revenue Branch to rectify the revenue record
Where is that order?
of the land. Impleading order, Your Lordship, page 21, Annexure 3. Lordship has got it. First two paragraphs will be relevant, and then page 20.
Mr. Jami, the same problem here also. Why you are moving 226? These are orders being passed in connection with the declaratory suits.
Your Lordship.
Then why you are moving 226?
Your Lordship, the problem is the order has been passed based on the judgment which has been passed by the learned civil judge senior division in a declaratory suit and subsequently upheld by the principal district judge in appeal, Your Lordship. But the case of the petitioner is that in the proceeding, both in the proceeding before the learned civil judge senior division as well as before the principal district judge, Your Lordship, the petitioner, she was not a party. So my case is that judgment passed in civil proceeding cannot be executed against a person who was not a party to the state proceeding, Your Lordship.
Understood, but fact remains that you have to challenge that judgment.
No, Your Lordship, because I was not a party to that.
Understood, but if it is applied against you,
Lordship.
what has the DC done here? There is an order judgment passed by the civil judge.
Lordship.
This has been confirmed by the principal district judge.
Lordship.
That has attained finality.
Lordship.
Now, these are judicial orders which have been passed, which have attained finality.
Correct.
Now, on the basis of that, the DC is putting is in the form of executing the orders being passed. So, under such circumstances, if it is executing those orders, means it is giving effect to those orders. Unless you challenge those orders, how do you succeed here?
I have another submission. Your Lordship is right. The DC is executing the judgment. Whether a judgment can be executed, Your Lordship, in my respectful submission, only a decree can be executed, Your Lordship. And if I have to file an appeal, Your Lordship, appeal cannot be against judgment. Appeal has to be against a decree, Your Lordship.
Appeal against?
Against a decree, Your Lordship. Not against judgment.
No, I'm not saying filing an appeal against this order. No. I am saying on the merits of this matter, wherein there is a judgment rightly or wrongly passed by the civil judge as well as the principal district judge. These orders have attained finality.
Lordship.
Now, on the basis of the judgments, the DC is implementing those orders.
Subject to Your Lordship's satisfaction.
Yes, please. I am
Now,
always.
the judgment, Your Lordship, in my respectful submission, it has to be executed. That there's an execution proceeding, Your Lordship.
Very well. There is an execution
but not by
proceeding.
way of an administrative order, Your Lordship. And as per my information, Your Lordship, though the judgment has been passed way back on 10/3/2014, Your Lordship, till date, no formal decree has been drawn. Whether judgment can be executed by an administrative order.
No, here they have passed a judgment and order on 12/7/2021.
The main.
It's okay. There against on appeal has been filed by somebody.
Yes.
And against that, the principal district judge has passed a judgment and order on 12/7, whereby the judgment passed by was upheld and affirmed.
Yes, the judgment passed by the Civil Judge Senior Division was on 10/3/2014.
Yes, maybe.
Yes.
But the moment that judgment has come in appeal, and the appellate authority confirms it, so it becomes, therefore, the doctrine of merger has already taken place.
Yes.
And therefore, 12/7/2021 is the effective judgment and decree. And the trial court judgment, if it is upheld, what has been held out there would become executable. Now, your submission as it appears is, without there being an execution proceedings,
And without there being a decree, decree has to be by the original court. The appellate court cannot draw a formal decree. It is for the.
No, yes, there might be not be. You see, the problem which arises is, you have to, yes, strictly speaking, there has to be a decree.
Lordship.
And judgment, but we can very well ask the civil judge to draw up the decree, that's all. And then proceed with the execution.
Correct.
Who is paying for the private respondents?
No, I have not made up a party because.
You have to make them a party, because they would be affected.
When they have not made me a party in
They
the
have not
proceeding,
made you a party, but because of their judgment, you are affected.
I am going to be affected. They know it. They have not made me a party, Your Lordship.
No, Mr. Jamini, you
And
have to make them a
and
party.
here I am only questioning the action, the order passed by the Deputy Commissioner, whether he can execute a judgment.
Understood, but without making them a party.
No, the
Because
DC.
because the moment I say that this cannot be done, because of their right is affected somehow. They may not be a necessary party, but they would be a proper party.
That Lordship, that liberty may be given to make them a party.
Upon hearing the matter, this court had put a query upon Mr. T.B. Jamil, the learned counsel appearing on behalf of the petitioner, as to whether these petitions at all would be maintainable without arraying the plaintiffs in.
Declaratory suit 6.
These are all separate suit or same suit?
There are two suits. Declaratory suit 6 and 7. It's reflected in the order, Your Lordship.
Without impleading, without arraying the plaintiffs in declaratory suit number 6 and 7 of 2005 as party to the instant proceedings. Mr. T.B. Jamil submits that they would not be necessary parties, but they would be proper parties. In the opinion of this court, the plaintiffs in declaratory suit number 6 as well as /2005 as well as 7/2025 would be proper parties, and in their absence, any adjudication so made, and it is necessary in the opinion of this court, the plaintiffs in declaratory suit number 6/2005 as well as declaratory suit number 7/2005 are proper parties, and without impleading them are necessary parties, and without impleading them the instant proceedings cannot be proceeded with. Liberty given to the petitioner to implead, to file appropriate applications impleading the plaintiffs in declaratory suit number 6/2005 as well as declaratory 7/2025. Mr. T.B. Jamil, the learned counsel, submits that the same would be done within a period of 4 weeks from today. List the matter upon filing of such applications.
Obligation.
For admission, item number 13.
Yes, what is this, Mr. Mohajumi?
The state has already filed the affidavit and they have stated that.
Regularization.
Yes, Lordship.
Well, have you gone through the recent judgment of the Supreme Court on regularization?
Lordship, the state has formulated a policy, Lordship, in the month of March 2025.
Petitioners as contingency sweepers under the establishment of area should not be regularized. No, why I am saying it, why it is relevant.
Lordship.
You have a look at this judgment.
Lordship.
Because before coming to Kohima, although I don't take up this matter, this bench in the principal seat, then I got hold of this judgment, so I thought that this is very essential while dealing with all regularization matters.
Lordship.
It is a judgment in the case of Dharam Singh versus State of UP.
Lordship.
I have a copy of this. I'll put a photocopy in this file also. Have a look at this. I think give him a copy of it. We'll have it on some other day. Have a look at it, this, because this may help you out.
Lordship.
What the Supreme Court says, you can't keep somebody,
Lordship.
contingency, contract, whatever may be, for a long period of time.
Lordship.
Now here you are saying that whether contingency workers, who the petitioner was appointed in the capacity of a contingency worker,
Lordship.
can be brought within the ambit of the Office Memorandum dated 17/3/2015.
Lordship.
That's it. But this judgment, I think, may help you out.
Lordship.
And we'll hear again some other day.
Lordship.
Because this, I think, there are strict directions being passed.
Lordship.
That if these people have been working for long, not only that, it is the constitutional duty or obligations cast upon the state to create jobs, to create posts for the purpose of AI, because for a long time you can't keep them. When should we have it?
Monday or Tuesday at the convenience of this honorable court.
Objection, Lordship.
List the matter again on and list this matter again on 1st of September 2025. First, you go through this, Judge.
Bring it here.
I pledge.
Lordship may pass similar order in the next item. It's also a similar case.
1st of September. Ms. Livika,
Lordship, this is regarding the
that matter,
retrospective.
no, in that hearing matter, I have given 2 notes. You have got it? Yes, please have a look at it. We'll hear on Wednesday.
Yes, Your Lordship, I also have some documents.
Yes.
May I bless your Lordship? Lordship, here I received my parawise comments. Lordship, however, further clarification is needed. So if I may be granted some time to receive the instruction as well as to file my affidavit, Lordship.
You have not filed affidavit?
Lordship, recently I have received my instructions, so Lordship.
You received?
Lordship, further clarification is needed. So
How much time?
3 weeks time, Lordship.
You have received instruction, then also 3 weeks.
I need further clarification, Lordship.
Ms. So-and-so appearing on behalf of the respondent state submits that though she has received the instructions, but while preparing the affidavit, further clarifications is necessary. She therefore submits that 3 weeks' time may be granted in that regard. List this matter on 11th of September 2025. Affidavit in the meantime be filed.
Lordship, there are some similar matters, if it can be clubbed up together. Initially, case numbers, Lordship. All the 4 matters are similarly situated, Lordship.
Mr. Muazzamid, appearing on behalf of the petitioner, submits that there are other 4 similar matters.
Other 3, Lordship. The present one is serial number 2, Lordship.
Other 3 similar matters, being WPC number
82 of 25.
82 of
Serial number 1,
2025,
and 74 of 2025,
74/2025,
and 104 of 2025.
104/2025, which are wherein similar issues are being raised. First of all, the 3 writ petitions be also listed along with the present writ petition on the next date.
I pledge.
For orders, item number 17.
Yes, Your Lordship. Lordship,
Yes,
in this
Ms.
matter,
Mary.
I'm yet to receive instructions, so I may be granted a further time of 3
None
weeks.
appears for the petitioner. Petitioner is not appearing and you are asking for time after time. You are there for the petitioner.
Appearing on behalf of Lima Longzer for respondent number 8.
First day, it has not come up for motion. Motion is there.
Motion is.
So and so. You have not filed your affidavits.
No, Your Lordship. I'm yet to receive
You are
instructions.
appearing for the petitioner.
Yes, sir.
Okay. When are you filing your affidavit?
I'm yet, after I receive instruction, I'll be filing soon.
But they can't keep on delaying it. What is the case about?
The plea of the petitioner is that another contract person has been appointed against his post. Another person has been appointed against his post.
Has the petitioner been terminated?
That I have no idea, Your Lordship.
How can it be not there for such a long time? The notice has been issued by just Brother Sema when he was here.
Yes, Your
He has
Lordship.
already retired also. But we are yet to get the basic information as to whether the petitioner has been terminated. Has the petitioner been terminated, Mr. Counsel? Has the petitioner been terminated or is the petitioner still discharging her duty, his or her duty?
Sir, to be honest, our main counsel is on the way from Mokokjong and I am appearing on behalf of our leading counsel.
You are not aware
Yes, sir.
whether the petitioner is terminated or not.
Sir, our main counsel didn't inform me anything about that.
Okay. Can't help
So
it.
I'm just here for the update.
Ms. Esmeri, the learned counsel appearing on behalf of the state respondent authorities, as well as Mr. So-and-so appearing on behalf of the respondent number 8 and 9?
8 only.
8 submits that they have already, they would be filing the affidavit within 4 weeks to establish this matter on 15th of September, 18th of September 2025. The affidavit filed by 16th of September 2025.
Obliged, Your Lordship.
Thank you.
Item number 18.
What is this?
No, the Lordship,
Blue file?
the present is it's been filed for deletion of some petitioners, Lordship. For deletion of some petitioners. On the ground that while pending disposal of the main writ petition, and many of the petitioners, there's 78 of them have been,
Strike out the names of the petitioners.
Lordship.
So many.
Lordship, but these 78 petitioners, they've given the benefit of regularization, for which I've included
So
your
you want the names of these being struck off?
Lordship.
Yes, sir, to that extent, no problem. No objection.
This is, I heard Mr. So-and-so, the learned counsel appearing on behalf of the applicants, and Ms. Livika, the learned counsel appearing on behalf of the respondent numbers 1 to
Lordship,
4.
here I'm appearing on behalf of my colleague, AIN.
I put your name, you are there, 1 to 4. Gustav. The counsel appearing on behalf of the petitioner applicant submits that the petitioner numbers, a paragraph number 2, this, 106 बहुत की बार नाम से, हाँ, have in the meantime already been benefited by the scheme of regularization. And as such, these petitioner applicants, who are the petitioners, would not like to further pursue the instant writ petition, accompanying writ petition. Ms. Livika, the learned counsel appearing on behalf of the respondent, submits that she has no objection in respect to the said prayer. Accordingly, this court therefore strikes out the names of the petitioner numbers a number gutigita prayer tasadi gutigita d from the accompanying writ petition. Full stop. Next. In view of the aforesaid order, the petitioner would now it would be required on behalf of the petitioner to rearrange the remaining petitioners in the accompanying writ petition. And accordingly, after necessary deletion being carried out in pursuant to the instant order, the counsel for the petitioner is directed to rearrange the remaining petitioners in the accompanying petition, and thereupon file a fresh memo of parties before the registry of this court. First, the registry, upon such fresh memo of parties being filed and taking into account the directions so passed in the instant order, make necessary correction in the cause title of the writ petition and update the same in the CIS. IS stands disposed.
Your Lordship, in the main case, the government is yet to file.
You want to file affidavit?
Yes, 3 weeks. Yes.
Ms. Livika submits that she has received the instructions and will be filing the affidavit within 3 weeks. List this matter on 18th of September 2025. So affidavit will be filed by 15th of September 2025.
One is petitioner.